by the past, it surely should not be limited by today. As my Lord Justice Nagaratna was pleased to observe, my Lord, that supposing in future the Parliament finds that this privatization exercises which are being done become stressful, harmful, and obstructive, if I may go to this extent, to the further march. So everything, Lord, in economics, Lord, a time comes when it becomes, at a time is when it is helping the further growth, a time comes when the very same thing becomes obstructive. Then you have to change courses. We may go back, you may go forward, further forward. All sorts of experimentation should be allowed to the Parliament. And the court should then see, Lord, as and when the exercise is done by the Parliament, and then see what has been done, Lord, is it going too far into the private domain? Surely no Parliament will be interested in taking away the spectacles and the watch of the individuals. But that kind of private property is not a resource. I bought a spectacle and I don't earn from it. In Hindi, we call it Samudayic Sansadhan. So it's the resource of the community. I must be able, if I have one house, a hutment, so no Parliament is going after the hutment of that Dalit Mulad who is living in the village. First of all, there will be the democratic check. If they do that, surely they don't want to last. But quite apart from that, it doesn't mean to say that there should not be a judicial check if possible. But that's not a resource of the community. It's not a resource at all. So there is a private property construct wherein will fall a large number of ownership of individuals, which is not actually a resource at all. It's for personal use. Somebody's cycle, somebody's scooter or motorcycle in today's modern world, they're all, or refrigerator, these are all modern needs of the person. That doesn't result in any further source of income or profiteering to the individual. So what was being targeted was the private monopolies, the private profiteering, the concentration of wealth, as they say in 39C. So these are the guiding things, Lords. Some learned counsels said on the other side that 38 is separate, 39B is separate, 39C is separate. It's not like that. Even the preamble projects itself into the directive principles. 38 projects itself into 39B and C. They don't stand in isolated glory. They strengthen each other. The purpose is identical and same, and that is economic justice, as Dr. Ambedkar put it. Justice, social, economic, and political. So this is surely not political, this is in the economic sphere. Economic justice, therefore, he spoke of in the context of 39B.
Yes.
So idea is to equalize, which means there are those people at that time in 1950s, and even subsequently, there will be people who are owning a huge wealth. And all we know, my Lord, and we read every day that inequality is growing. So with all this privatization, the growth of GDP, we have side by side. So along with multi-stories and big mansions, etc., we find the slums. So this is a product of privatization. Privatization is at the same time resulting, and we are watching it. And the whole world today, my Lord, wants, the entire country, at least India, looks forward for equalization. So some method will have to be brought about, some policy will have to be evolved, maybe by taxations, by delivery of welfare goods, products. So please construe 39B and C as broadly, as widely as the framers of the Constitution envisaged. And my humble plea to your Lordship is in this domain, since economic justice is a flexible phenomena, please do not draw a line. Except that line which ineluctably, necessarily, compulsively flows from 39B. With this, if your lordship looks at, see how 38 to how broad it is. Eliminate inequality in status, facilities, and opportunities. Some methodologies are prescribed, Article 14, 15, etc. There is a continuous conflict between equality in fact and equality, which is called formal equality. This conflict will go on. It's a continuous phenomena, unceasing, requiring constant, continuous attention at attenuating or eliminating it. That's the message of preamble, that's the message of 38, and that's the message implicit in 39B and C. So keeping this in mind, my lord, please construe 39B. Let's look at it independently. There was one contention, my lord, that this talks of distribution, not acquisition. Acquisition stands before you distribute, you have to acquire. One more aspect may be kept in view, my lord, is it is not that but for 39B and C and 31C, acquisition is impossible. Acquisition under eminent domain, under the Land Acquisition Act, etc., can be done for public purpose. Even private property, even the hut plot which comes in the way of making the road plot can be acquired and compensated for. So private property is not beyond acquisition at all, even in the general law. All that this provision is now doing is, your lordships are scrutinizing, is whether protection of Article 14 and 19 should be allowed to be taken away or not. Not that private property cannot be acquired. But once you declare 31C, it will not be there. So once 31C declaration is there in the Act, and it has nexus to 39B and C, then 1419 is shut out. That's all that happens here. And it is this limited domain which we are scrutinizing. So acquisition of private property is not sacrosanct, nor is it something which stands away from the domain of 39B. Now 39B, there cannot be a distribution to subserve common good unless acquisition happens. So acquisition of private property, ownership and control. So some private person's ownership has to be taken over in order to be distributed. And that in which the state, which organs of the state, including parliament and state legislatures, have to move There was some debate that in Article 38, the word strive should be deleted and substituted by some lighter word. Dr. Ambedkar said that this word has been deliberately brought in so to compel them to move in this direction. The most important goal for any parliament or legislature is to move towards equalization. It's unfortunate that inequality is still growing, and that's something to be tackled. That's the constitutional mandate. But 39B, in the context of Article 31C, involves the inclusion of declaration. So when 31C comes in along with 39B, then it's a source of power to make a declaration. Your lordships are called upon to look at 39B in the context of 31C. And 31C if it has to be invoked.
Not require a declaration.
No, it doesn't talk of declaration.
That latter part brought in a declaration. That if there is a declaration, you will not review the.
As the learned Solicitor General said that even if you don't have a declaration, still court can see. But if the legislature expressly says so, then your lordship will see the nexus. Once the nexus is established,
then the conditions for 31C arise.
So in order to bring in 31C, the legislation must speak. I may not call it declaration, it must speak expressly. That because 14 and 19 are being shut out, so it must speak expressly or by necessary implication. So this is a power which is emanating from 31C. So when 31C comes into the picture, then this power and duty to speak about the invocation of 31C to shut out inquiry based on 14 and 19, for enforcing and implementing 39B assumes the shape of a power, which of course would be connected with 245, 246. And in that context,
31C is not a power, it's a limitation on legislative power.
But in as much as
immunity to legislative,
in as much as it is
it's immunity to legislative. It's not a limitation, but it in fact is an immunity.
The effect of invocation is immunity.
Right.
The effect of invocation is immunity, but the power to invoke, but for 31C, Lord, this can't be shut out. So the legislature must invoke 31C. (245, 246) by itself would not enable shutting out 1419. That is subject to 14 and 19. It is 31C alone.
Which must be a law giving effect to the policy.
That's right.
Of the state towards securing Article 39.
That's right. So state will have to speak expressly or by necessary implication that it is to secure, the law is being made to secure this. In which event, 1419, then the court will only examine nexus, reasonable and direct nexus. So therefore, coming back, 39B, when it says ownership and control, it was rightly submitted that the word and has to be read as and stroke or. And this is not unusual. My Lord, the Chief Justice, Lord, and the other learned judges have in Jindal Steel, in the context of Article 301, read it in that manner. If your Lordship has not, I have two volumes, volume 2H and 2N. Finally, I have paragraph 20 of 2H, volume 2H.
What page?
Page 8.
Para 20.
Yes. I have quoted for convenience para 75 of Chief Justice Thakur's judgment. If your Lordship will come down 10 lines from the bottom of that paragraph. The word and can mean or as well as and, depending upon the context in which the law enacted by the legislature uses the same. Suffice it to say that levy of taxes do not constitute a restriction, then that goes on a different. Kindly have, my Lord, the Chief Justice Chandrachud's judgment. The word and is normally at the bottom of the same page. The word and is normally used in the conjunctive sense. However, this is not always the case. Coupled with the use of the expression may, the expression and in 304 should be construed to mean and stroke or. In other words, the legislature of a state may take recourse to both or either of them. So I would say, bro, this happens when a power is conferred, then it's not essential that the entirety of the power be exercised. It's from this that this idea is flowing, as my Lord the Chief Justice has put it very clearly. And then in the next paragraph 653, both and or are inherently ambiguous and is always conjunctive in the sense that it always signals and cumulative of the possibilities listed before and after the and. However, and is ambiguous in that it may be joint or joint and several. In the case of a joint and, every listed possibility must be included, both A and B, all of A, B, C. In the case of a joint and several, and all the possibilities may be but need not be included, A or B or both, A or B or C, or any two or all three. In other words, the joint and several and is equivalent to and stroke or. For the other learned judges, I have mentioned the paragraphs at the end. So, in fact, as the Solicitor General, the learned Solicitor General said, submitted, and in this context of 39B, ownership and control should be both and or leaving it to Parliament, either to take control, either to take acquire, or to do both. So whichever subserves the good, that's the guiding star, and for Parliament to do. Take note of it. And it is not that acquisition has to be done first and then something else, step 1, step 2. It's all common there in 39B. If they are together, every law of acquisition need not stand alone. Nowadays, not all laws, as Your Lordship, my Lord the Chief said in the earlier cases, drag back. You can have one law, acquire and distribute. You don't have to have a separate enactment. And to separate it, acquisition from distribution in the context of 39B frustrates the whole purpose of 39B. Because the idea is to equalize, take from some and distribute. The second expression is distributed. How do we look at distributed? And I would submit with respects that the word distributed should be construed as a part of the entire phrase in which it occurs. So distributed as best to subserve. So distribution will not mean in every case distribute by bits and pieces, piecemeal, by metes and bounds. It may be in case of land where zamindari abolition, you take the land and distribute it to a large number of people. But in another case, let's say of spectrum, which is undisputedly a property of the community, a resource of the community. Now, this spectrum is not to be distributed by bits and pieces to the people in the country. There would be an auction or a tender, and somebody will get a lease or a license, and then he will set up the whole structure based on which the community will then be benefited. So that's another way of distribution of the benefit of the resource to the entirety of the community. So therefore, distributed will not mean always distribution in bits and pieces. And that's why it is part of the phrase, so distributed as best to subserve. There can be a large pond, for in Bengal, where we are standing, there are non-agricultural property, which is one of them is pond. And there are huge ponds, 500 acres of pond, or even more. So now water can't be distributed because we set by concrete, divide it, and small portions given to a large number of people. So what can be done is that you take it over and give it to some cooperative society of a large number of people living around, and then they can utilize this pond. And there's another fear that the ponds the private owner may feel that it's my property, so I'll fill up the pond. And we'll have a huge skyscraper there and earn money out of it. So these are choices which are restricted. As the Lordship said, that private property, the Chief Justice said that private property, there are certain private properties which inherently provide sustenance, or they are in the interest of community is inbuilt in that private property. There are private forests, there are wetlands. Now, this word distributed has been well, for construction, Lordship may note para 92 of Kapoor Bhai's judgment, volume 5, page 238. 2348 it begins, and the relevant portion at page 2381, para 92. In 91 and 92. Other dictionaries are also mentioned earlier paragraphs. May I place para 92? Yes, 1984, 1 SCC. 515. May I place it? It is obvious, therefore, that in view of the vast range of transactions contemplated by the word distribution, as mentioned in the dictionaries referred to above, it will not be correct to construe the word distribution in a purely literal sense so as to mean only division of a particular kind or to particular persons. The words apportionment, allotment, allocation, classification clearly fall within the broad sweep of the word distribution. So construed, the word distribution as used in 39B will include various facets, aspects, methods, and terminology of a broad-based concept of distribution. In other words, the word distribution does not merely mean that property of one should be taken over and distributed to others like land reforms, where the land from the big landlords are taken away and given to landless laborers, or for that matter, the various urban and rural sealing acts. That is only one of the modes of distribution, but not the only mode. In the instant case, as we have already pointed out, distribution is undoubtedly there, though in a different shape. So far as the operators are concerned, they were mainly motivated by making huge profits. and were most reluctant to go to villages or places where the passenger traffic is low or track is difficult. This naturally caused serious inconvenience to the poor members of the community who were denied the facility of visiting the towns or other areas in transport. By nationalizing the transport, as also the units of the vehicle would be available to go to the farthest corner of the state and penetrate as deep as possible and would provide quicker and more efficacious facilities. This would undoubtedly be a distribution for the common good of the people and would be covered by 39B. So therefore, there will be various shapes in which this distribution can happen. Now the third expression, the next expression which in 39B is material resources of the community. So there are two parts. One is to look at material resource and then material resource of the community. As the lordships have laid down in various judgments, that one of the modes of construing is to dissect, break up the components, but not to stop there, but to reassemble them and then look at it as a whole. So dissect, separate, construe, and then see how the meaning fits in the as a whole in the context. So material resource, the resource, all resources which produce an income, they are a resource. As literally interpreted, contextually interpreted, and the interpretation has to be wide, except that which is non-productive of benefit, service, income, and is essential for living. For one has to remember that Article 21 is not part of it. For we have to remember that Article 21 is not part of this protection. So the right to shelter, right to livelihood has been held to be there in Article 21. So therefore, that private property, which is not productive, which is not a resource, but is purely for personal benefit, is not covered here. Otherwise, all other private property should be held to be within its ambit in its widest plenitude. And it should be left to Parliament to decide which one to touch or not to touch.
Whether it is tangible or intangible.
Tangible, intangible, all kinds of property. We don't know what will be the scenario. That's the problem today. We cannot prognosticate what technology, artificial intelligence is now coming in. Robotics is now coming in. So what all will your lordship visualize in laying down a line? We will be back in the court again.
So you mean we should not?
Yeah, I'm saying that your lordship should not leave it to the Parliament. This kind of private property which I'm talking about, this property, no Parliament is going to touch.
The others also, they can acquire the properties. Why not?
Sorry,
They can acquire also the property for distribution.
yes, of course. The point is, in certain cases, the Parliament feels that Article 14 and why did 31A, 31B come along? Because in the very beginning in 1951, the Constituent Assembly was acting as a Parliament, and it felt that 31A and B have to be brought in. Because the laws of this land reform laws were being struck down by courts on the anvil of Article 14 and 19(1)(f) and so on. So it felt that on the one hand, we are compelled to have these measures to equalize, to uplift the downtrodden. And on the other hand, there is an interpretative exercise in the courts which is coming in the way. So therefore, they wanted to shut it out. So it happened right in the beginning, 31A, 31B. And your lordships have said that in Keshwanand, that 31C is nothing but an extension of 31A. So yes, my lords are absolutely right that acquisition can happen. That's how I started, that acquisition of all kind of property can happen. Even the poor man's hut can be acquired if a road or a canal or dam or a metro has to pass. But there they have to pay compensation, market value, and all those concepts come in. And that was one of the basis for striking down of various laws, that the compensation are not being provided to the zamindars. Therefore, the parliament wanted to avoid it, and they brought in the constitutional amendments to ensure that these questions do not become an obstacle and the country marches ahead. The agrarian reform, my lord, was a objective set before in the freedom struggle itself. And Article 51A says that it's the duty of every citizen to cherish the noble ideals of freedom struggle.
Lahore resolution.
Yes, in Lahore Resolution 1929, as early as that, Pandit Jawaharlal Nehru was the president, and he was the pioneer of this agrarian reform. So agrarian reform, even before on the anvil, when we were on the anvil of independence, it was put forward and coupled. Please see, I'm grateful to my Lord Justice Dhulia. 1929 is the Lahore Resolution. 1931 is the Fundamental Rights Resolution of Karachi. So fundamental rights and the directive principles all were emerging simultaneously as a cherished noble ideal. So that's the blend, that's the balance which Chief Justice Y.V. Chandrachud talked of in the Minerva Mill. They said the two wheels of the same chariot. And balance is the basic structure. That's the most important statement. Balance between the two is the basic structure. And sometimes this balance in some situations demands that some fundamental right be kept aside and not become an obstruction in the forward march, the further development or the upliftment of the downtrodden, the Dalits. So therefore,
31C itself is in the fundamental rights chapter.
that's right, I'm good. It's this part of the same scheme is as fundamental now. Read 39B, when in the context of 31C, virtually takes the shape of a fundamental right. It is actually a fundamental right because some people should not enjoy fundamental rights. By equalization, we take the fundamental rights and make them live real for the poor people. So that is to be realized. Everybody must enjoy the fundamental rights. So education must go down. Economics must ensure that the fruits are going to the people and to those who are laboring. So I submit, my lord, the only word now remains is community.
No, about this material resources. So should we assume that you are not making any distinction between property and material resources? You think they are the same?
All property, yes, but everything is property today, my lords. The concept of property started emanating when Lord John Locke started defining it in the context of occupation of America.
That means that may be, suppose somebody here discovers a cure for cancer today, right? That's his property in a way.
Yes.
That also become a material resource?
It is intellectual property, Lord.
No, but intellectual property, there is a privacy attached to it. There
No,
are a whole lot of things.
I'm not
What
denying.
we are saying is, once you include tangible, intangible, everything is material resources, then that has to be decided, isn't it? Because this reference is for that only.
Yes,
This reference is for that only, that
absolutely.
whether private property constitute material resources or not.
Yes.
So a distinction has to be made, or whatever, this has to be touched upon.
Plus, let me put it like this, Lord. When we talk of an idea becoming a patent and therefore a right of that individual, that idea itself is a is a social product. My idea taking shape in my mind is not sitting in a jungle that I have formed that idea. The society has contributed in my upbringing and growth, and therefore that idea just as bare me. I mean, I may be completely off track, but just kindly consider
We are with you on that.
So now what happens? Now an idea is taken, somebody gets a patent of a cancer treatment. Now he says it's my property, I'm not going to aid the society in cure. Or that I will set up a hospital and then I will have such a high charge for it that people are not benefiting. Now, is the parliament then incapable of saying that it may be your property, but the country needs it? People are dying. So we make a law, therefore. So there can be a variety. All I'm saying is leave it to the parliament. How will your lordship draw a line that this particular idea, this particular property should be out, this should be in? That's a very cumbersome exercise. An impossible exercise, I would say.
Oh, that's a good, I mean,
We will be,
I'm willing to accept that idea that, you see, then there is nothing like an intellectual property. Because before it becomes an intellectual property, it is in the nature.
yes,
It is in the nature before it becomes your property.
that is so.
So if that is so, then you are, that idea may not be acceptable to everyone, you see.
No,
You will accept.
if it's accepted to 9 of your lordships, I'm satisfied, my lord. I'm not concerned with everyone standing outside the court. Surely, as my lord, the Chief Justice said, there are Gandhians, there are Marxists, there are socialists, there are Fabian socialists, and so on. So each looks at the developments in its own way, my lords. My lords are absolutely right. Many may not. But here we are concerned with this, which the framers have made. And Constitution is a document, my lord, where every two persons will have a different view of it. That's the beauty of the interpretation exercise in the context of Constitution. There's no one. But which is more beneficial, my lord, where should, drawing a line, keeping out, how will you do it? Is entering into a boggy ground, my lords.
But assuming that material resources would include all kinds of property except those which are earmarked for personal use, as you said. But what about the words of the community?
Yes.
Does that interpose some sort of limitation
lords,
on what can be regarded as a
Now,
part of that
community,
phrase?
yes, I was coming straight to that only, my lords.
Community, and what should we understand as community?
Sorry, my lord? Community,
How do we understand community?
material resource.
Community also.
Community, yeah.
Of the community.
Yes.
The community does not necessarily mean the entirety of the population of the country or the state. Community would also be relative to the resource.
Yes.
So now let's look at it this way. Community, literally speaking, means a combination of it. Even two persons will be a community. In America, there is a Community Property Act, which deals with spousal property, which provides that all the property of the husband and wife together, whoever has whatever income, it will be shared equally. Its title is Community Property Act. So property earned by two persons will be a community. A firm, unless now, of course, we have a one-man company. So two persons in a firm, community.
Makes sense. Like, I'm sure you are aware of that. In UP, there is a law that in the pond, in the pond, the local villages, the fishing rights, the first charge is about the fishing community. So the fishing community will be given those rights first. So in that sense, for the fishing, the community will be only fishing community to get those resources. But for a larger thing, the entire country may be the community.
Maybe.
It depends upon the context.
Yes, of course. Maybe different spectrum. Whole country owns the spectrum. Everybody must get the benefit of the spectrum, use of spectrum.
So the community has to be seen in the context. In the context.
That's why it is relative. It is relative to the resource.
Yes.
Relative to the resource.
How broad the section of community will be benefited will depend upon the particular resource.
Yes, that's it. What did you say?
But resource it is.
What did you say just now?
How broad a section of the country will get the benefit of a particular resource would depend upon the nature of the resource. And where it is located. The very locale will restrict If it is in Bengal, my lord, surely the fishermen of other states would not be traveling there, can't be given the benefit. It has to be, and the resource is also limited, not the locale alone, but even the size of the resource. But ultimately, if we go strictly by private property concept, as my learned friends want, then the pond belongs to a private person. He will say, why? It's my property.
Or if you have a mining lease, he'll say, well, it's my
Mining lease,
property.
my property. Lord, actually, nobody was born with land and ponds and rivers and sources. But ultimately, this is the private property is a concept of law and is a concept of material development of the society.
And even if it is strictly private property, like say a lease creates an interest in land.
Yes.
It's a lease for mining purposes. Nonetheless, we've always accepted that there may be a regulation in the interests of the wider community.
Yes.
Because there is a community interest in regulating even private property. So for instance, in the case of mining, that there should be sustainable mining. That you should not completely depredate the earth of its mineral resources.
Yes.
And therefore, the very notion of community interest postulates that there is, even in relation to property of a private nature, an interest of the community in proper regulation. This is in the interest of proper distribution, so as to subserve, that the ownership and control subserves the common good.
And it goes to the credit of Parliament. Lord, in the last 75 years, how many times this has been invoked? Even the Mines and Mineral Act, Lord, 1957, your Lordship saw in that other matter, doesn't have this declaration, 31C.
No, but that is because of, first it was curtailed by Keshwanand Bharti and then by Minerva.
No, I'm not on that. I'm saying that we must give credit to the Parliament that it is not using 31C, Lord, blindly right, left, center, everywhere, Lord. Even in mines and minerals, since my Lord the Chief Justice gave that example, therefore I'm pointing out that in the previous exercise. Yes.
You gave.
Distributed as best to subserve the common good. Now, when you subserve the common good in a given situation, you may be serving various common goods or benefiting various needs of the society.
Absolutely. For example, in the pond itself,
This pond example.
fishing is one aspect. All the cattle of that, they come to drink water in the ponds. That's another interest. People come to the ponds to take bath there. So
You can't be forgetting the buffaloes who wallow in this water.
yes. So when they are wallowing in them, there's little difference between the humans and the buffaloes. They all wallows together. In the villages, I've worked for 4 years with the downtrodden, so I've seen that phenomena. Where on the one side the buffaloes are in it, and on the other side the human beings are also. The ponds are very, very important for the village community. The only thing is that individual interest up to a point is to be protected, but there can be points raised where the society, the parliament feels compelled that no, we have to do something with it. And we don't want to get embroiled in this long drawn litigation. Well, kindly see it, after 20 years, these litigations are coming before your lordships. और कुछ है नहीं. respectful submission means the people. They may also be individual people. They may be couple. They may be more than two. Communities cannot be limited to state. There is no color of state ownership there. It cannot be that Air India, my lord, when it was owned by the state, it was a material resource. The moment Tata takes over, it ceases to be material resource. Now that will be, there's another reason.
Engagement between people, because
Yes.
people become a community when you engage with them.
So today there's so much.
Maybe it's an engagement on just social interaction, professional interaction, religious interaction,
Or even economic.
or economic interaction.
Yes.
Some engagement between human beings is implicit in the concept of community.
Now let's.
There has to be some element of an interest of the community in order to make it a material resource of the community.
No difficulty in all these things. My lord. The only problem will be at what point of time the interest will emerge.
That's a matter to be decided according
So
to
that's right.
context.
So therefore, my lord,
You can't
for us
attempt
to
an
draw a
exhaustive,
line, all I'm
an
endeavoring.
exhaustive definition.
My lord, right. So if my endeavor is limited to this, that it's very difficult in judicial review here, my lord, today to draw a line, my lord. That line may be crossed very soon. Such is the life, my lord. So it will present another problem. The best is to entrust and then see, my lord, where is it going? Is it going so far as to touch somebody's personal belongings, my lord? In that sense, which is not a resource, which can never be distributed for common good. So nobody can take my spectacle and say it is can be distributed, or everybody can't wear it, or everybody has a different eyesight problem. So it can't be distributed for common good. Yeah, personal effects. A better way to put it is the personal effects. So community, in my view, Mullers, is just people in their engagement, particularly economic engagements. And common good, of course, is again relevant. As I said, does the acquisition and distribution which is contemplated, is it serving the common good? But that will be sitting again in judgment, my lord, can't be a subject matter of judicial review. Lord, all that is therefore covered by the word nexus. Direct and reasonable nexus is for that purpose, which the court will see in judicial review.
No, but to see that nexus, we'll have to see whether it is for the community, whether it is a material resource or not. That much has to be seen.
If the lordship accepts my submission that community is very wide and therefore, then of course, there is little to be determined. Now, one more aspect is there, Lord. Today, the question is whether private companies, Lord, should be covered. Lord, what is a private corporation today? Even if every corporate promoter is today operating on the strength of depositors' money, which through the intermediary of banks, financial institution, is then given to them in loan and is utilized. A social interest, a community interest is directly there. If the corporation doesn't pay back the loans in time, the depositor's interest gets directly affected immediately. Then no production can happen in the manufactory of the corporation unless the labor power collaborates with the capital. And this is not Marxism. I am not afraid of Marxism. Our constitution, as Dr. Ambedkar said, we don't know which government will come tomorrow. It may be inclined to socialism, it may not be. That's what Dr. Ambedkar says. You also have read it. So leave it to them. We cannot say today that if tomorrow a government comes which is inclined towards socialism, then there will be an obstruction. You can't move towards that. That can't be the mandate from the court. So it's flexibility. Our constitution makers have kept it pragmatic, flexible. It's up to the people to choose the kind of government they want, the kind of growth they want, and therefore, it is neither Gandhian nor Marxist nor Fabian socialist. Notwithstanding that the preamble has been amended to include the word socialist. There will be a great debate, Lord, if one goes, what is this socialist? There are n number of kinds of socialists in the world. All kinds of socialists.
No, but it is there in Article 43, capital A.
Yes.
43, capital A is just what you're saying.
Yes, the state shall take steps by suitable legislation to secure the participation of workers in the management
And read further.
of undertakings, establishments, or other organizations engaged in any industry. So every corporation engaged in rendering service, trade, commerce, it's a community. Not only this, the shareholders are there. A body of shareholders contribute. There are debenture holders, bond holders. There are private money lenders. So there's no way, Lord, that this private corporation today can claim to be private in the sense at one point of time we enclosed a piece of land and said that it is mine, excluding the other. And closing the property and excluding others, which is the primeval form of private property, that doesn't exist. It is collaborative exercise today. Every private corporation, even if it is a one-man corporation, it will be borrowing money. It will be using laborers. And all those liabilities are there. And to top it all, they produce and manufacture for the consumers, which is a continuous exercise. Without the consumers, there will be no maximization of return, no profiting. They are seeking profits, and profits are coming from our pockets, Mullas.
From there, the taxes are going down.
And taxes.
That is used for social welfare only.
And government takes the tax, and when these corporations are in crisis, they go to the government, and government then supports them. So just look at it, this whole phenomena of industry and business today is a community exercise, nothing else.
OTS also.
Sorry, Mullas?
OTS also in the banking.
Everything, Mullas, nothing. That's why I'm saying, Mullas, that how do we define? So many imponderables are there, so much flexibilities are there. See, these words, if you watch it, it's really impossible.
This now
This
covers
completes this
now.
part of it, Mullas, except that if Lordship may just note at page 20, para 26 at page 12 of the note. I have extracted some portions from Justice Khanna, Justice Y.B. Chandrachud, as his Lordship then was,
In Keshwanand, right?
from Keshwanand, where they say that 31C is an extension of the principles of 31A. The relevant lines, I have made it bold, but I have extracted the whole paragraph. And the other learned judges, I have given the paragraph at page 16. Paragraph 30, page 17.
What else, Mr.
Now, leaving this topic, Lords, the other note, Lord, which he gave subsequently because the Lordships heard on the issue of survival of 31C.
We are on 31C now.
Yeah.
How much of it survives?
Not
And-
how much,
And,
Lord,
and
unamended.
its effect,
Unamended. And my submission is the entirety of 31C survives, Lords.
Your note is 2H.
2N.
2N.
2N. 2H was the one which I was reading.
Yes.
This is 2N, which has something of
Right.
39B also, but
Now on 31C, what is your point, Mr. Bedi?
not the first point on
Mr. Dwivedi,
31.
we will be rising today at 3:30. I have to address a conference in Tajikistan, actually, as part of the Chief Justice of India's responsibilities. So about 3:30, if we can rise.
Yes.
So in 20 minutes, will you be able to wrap up on 31C?
It won't finish, Lords.
How long would you take on 31C roughly?
I think I'll take about an hour now on this.
Then, Mr. Shankar and nobody else, right? Just Mr.
I think Mr. Shyam Devan is to, and Ms. Aishwarya.
All right. So tomorrow, of course, we'll go on till 3:30, 3:35 right now. But tomorrow, if Mr. Dwivedi, can you wrap up, say in about 45 minutes tomorrow by 11:50?
I can, whatever.
So
Is your lordship's
only
command.
then what we can do is that we'll give the others, Mr. Shankar, about 20 minutes. How long would you take?
I take a little longer than that. I have 11 points to make. Those are the 11 points which are covered by my 2 notes. But it requires a little bit of reading. There's some aspects have not been touched.
So long as all of you can complete by, say, 12 o'clock tomorrow, and then we'll give them 1 hour for the rejoinder. 1 rejoinder, 1 hour, then we'll wrap up. We'll complete at 1 o'clock tomorrow. We'll finish with lunch. I think that'll be okay, no?
Can I just indicate my?
For them for rejoinder, so that then we can have 1 rejoinder from them.
Can I just indicate my volume numbers are 2E and 2F for Minerva.
All right.
So I've the initial pages that are, as you know, voluminous, but my note
Yes.
itself has links to the annex.
All right.
So the initial note is 4 pages, the second note is 2 pages. It covers everything in that.
1C.
Yes.
What happens to 31C post
Yes.
Minerva?
And the learned solicitor has submitted that Vaman Rao and
There are 2 young men who also wanted to address for a few minutes each.
No difficulty, but this side we'll have to conclude by
Yes.
12, so that by 1 o'clock we conclude tomorrow. So between all of you, just talk to Mr. Diwan in the evening, so that, between all of you, you lay down a schedule. So that 12 sharp we'll conclude this side, so that 1 o'clock we can conclude the hearing. I think that will be fair for everybody. 1 hour.
I'll be taking 15.
No difficulty. 12 o'clock for this side and 1 o'clock for this side. All of you sit down together. 1 rejoinder. Any 1 person can make the rejoinder. We'll have 1 rejoinder. Because we follow in CBs, in constitution benches, we follow 1 rejoinder because. You want to make the rejoinder, we have no difficulty. Talk to all of you settle who will make the rejoinder.
Article 25?
25.
Article, which
25.
article?
If it remains as Article 25, what is the purpose?
20.
Who's
25?
dealing? We're not dealing with
We're
Article
not dealing
25.
with 25. This is the first time we heard 25 in the last 5 days.
The 31C post Minerva.
Just a question of 6C differences, so 6 and 3, 9 actually.
The purpose behind it, from that I will make some decision.
All right, yes, Mr. Dwivedi.
Just in that develop is fast. That's it.
Yes.
Because, so far as the interrelation between Minerva Mill and Vaman Rao, the learned solicitor general has made the submission, which I stand by that note and I adopt that part of it. Namely, that the 2 orders were passed on the same day. Dissenting judgment is common.
So 2 orders passed on the same day.
Dissenting judgment is common. And 2 learned judges, the learned Chief Justice and Justice Bhagwati, are common to the bench. They take note of the observations made in the judgments. So both judgments have to be read together. And in view of that, the unamended 31C should be considered as alive and operative. Now let me assume, my lord, that in Vaman Rao's case, since they were dealing with an enactment which is pre-Keshwanand Bharati, and therefore they were not really alive to this question, I'm assuming, that therefore these two judgments don't conclude. And we have to see then the effect of the declaration in Minerva Mill. I will not read para 75, your lordships have seen what is declared null and void and beyond Article 368 is Section 4. Which for convenience I have extracted at page 5 of this second note, 2N. Yes.
M.
N.
Yes.
N Panaka. Look, please, my first submission is, please draw a distinction between a declaration which says that the amendment is void. That is, the substituted provision is void. And a declaration which says that the provision which is substituting is void. I hope I'm clear. The substituted provision is void, and the other is that Section 4, which is trying to substitute itself, is void.
Aren't they the same? The provision which is sought to be substituted, ultimately it becomes the substituted provision.
That's the effect of Section 4. But Section 4 as a whole has been declared to be void beyond Article 368.
Examination was only to the amended provision.
Amended, whether it has.
No, look at the declaration.
No, final declaration may be, but examination was only to the amended provision.
That's, it had to be because the court was saying that unamended was narrow, amended is very broad, virtually brings in all the laws which can be contemplated, barring some few, and therefore the expansion, the enlargement is void and beyond the scope.
31B also this court says.
But
also
but we have to give effect to the declaration. Reasoning, my lord, is to understand how they reached the conclusion. The reasoning will not decide, my lord, the scope of or the effect of the declaration. For that, we have to see just the declaration and the effect, not how they reach that end. So the end point is not that this expression, all the provisions of Part 4 are struck down. There can be two. The court could have said.
Article 368 is really the amending power. And Article 368 as interpreted contains limitations on the amending power. So the declaration which our court issued was that the limitations on the amending power had been transgressed by bringing about Section 4. And therefore it was null and void.
Yes.
So therefore you are making a distinction between the substituted provision and the very process of substitution. The process of substitution was held to be ultra vires Article 368.
The whole process has been found to be faulty, beyond the constituent competence.
So if the process was found to be faulty, then the net consequence is that it did not result in a valid exercise of constitutional power, inserting it into the Constitution.
I'm grateful, but that's precisely not what I wanted to respectfully submit. That this doctrine of basic structure in Keshwan and Bharati, it was propounded as a limitation on the constituent power in 368. And this limitation is unlike a limitation on the lawmaking power which is provided for in Part 3 or in some other constitution provision of the Constitution. there are various provisions in the Constitution which in different contexts provide limitations. For example, 286, which was grappled in Sundararamayya, to which I will advert presently. So the consequences with regard to them is different. In 368 is a constituent power. If your lordship just see 368(1) itself, your lordship has seen that 368(1) says notwithstanding anything in this constitution, Parliament may, in exercise of the constituent power, amend by way of addition, variation, or repeal any provision of this constitution in accordance with the procedure laid down in this article. Now that procedure, necessarily we have to read Keshavanand Bharati's dictum, which means you cannot amend the basic structure, except the basic structure.
It's not so much a matter of procedure as of substance also.
Yes, or procedure is the special majority or ratification, in certain cases in proviso. So this is, you cannot do this. There are certain parts of the Constitution which cannot be destroyed.
But is there a distinction between an act being found unconstitutional, say, it may be found unconstitutional on the ground that it is lacking in legislative competence? An act may be found unconstitutional on the ground that it is contrary to a provision of the fundamental rights. Third, on the ground that it violates a substantive constitutional provision like Article 286. And fourth, that it is in violation of the constituent power. The 368 procedure is the recourse to the amending power
So if
has been held to be null and void here.
so if for the
Is
moment,
there a distinction in this area that we are looking at, depending on what is the ground for unconstitutional?
yes, I will advert to that, Manoj. But before that, let me dwell a little more on 368. If a procedure is not followed, for example, Lord, if it is not passed by 2/3 in its project,
Or you don't have ratification,
is
where
or
there is
that
ratification
something
required.
requires ratification, like, and you don't have the ratification, then it doesn't result in a constitutional amendment. It is as if it never happened, which means the Constitution never stood amended. This last expression,
Right.
thereupon the Constitution shall stand amended.
Exercise can be applied
Right
later
again.
time.
Yes.
It's a very
If it is
crucial expression, the word,
violating
sorry.
a constitutional provision, it cannot be brought back again.
So for instance, if you did not have a 2/3 majority and the constitutional amendment, it fails for that reason, you can still bring in the same constitutional amendment.
we can bring in,
Yes.
we can
But if it is violative of fundamental right, you can't
bring
bring that
it
again.
also back.
It can-
I'm grateful. That's the distinction between the two. But in one case, it doesn't stand amended. Equally, in the other case, it doesn't stand amended because basic structure cannot be amended. Please, therefore, this Keshavanand's dictum is very, very important. It has to be read into 368.
So where an amendment is found to be violative of the basic structure, is it your contention, therefore, it is as if the amendment never entered into the constitution?
Never entered into the Constitution. That's what.
What happens if an amendment is found to be violative of Article 14 or 19? There, does the amendment enter the Constitution, or it enters the Constitution but is declared to be void?
No, just allow me a little more breathing time to come to that. Fundamental rights, there are cases which my learned friends have also referred to,
Justice
completely
Matthews,
out of
nobody
context.
cited Ambika Mills, Justice Matthews' judgment.
I'll deal with all the cases with great respects to my learned friend, but they don't say what he wants to say. They don't say what he wants to say. It doesn't, they were entirely, most of them are in different contexts of Article 13(1). Balsara, Peshikaka, all these are on 13(1). Sundararamayya is breach of 286. They're not dealing with basic structure. It's very easy to attempt to transplant it from one soil to another soil, 368 context. But before that, one has to draw a parity. All these cases, but one streak is common. They all of them without exception say that if it is beyond the legislative competence, not 368, with respect to 7th schedule, they are null and void ab initio, ineffective, to be ignored. To be ignored.
Article 13(4) does not apply to a constitution amendment
Yes.
where it defines law.
Yes.
It does not include the constitution.
Except since your lordships have in Kolho said that 14, 19, 21 form the basic structure. So it can be abridged but not destroyed. Yes.
Equating, in other words, something which is lacking in legislative competence with something which is a violation of Article 368.
I'm saying
The consequences were similar, namely that there was no valid entry into the Constitution itself.
it never entered. That's how it is to be treated. That's how the declaration in para 75 has to be read. The Constitution did not stand amended in terms of the bill. The very bill is knocked out. Just have a look at the procedure, my lords, for a second.
If it is violative of legislative competence, there can't be a validating act by that legislature. If something is struck down as being lacking in legislative competence of the state legislature, Parliament may pass a validating act, as it does in the case of tax. Maharashtra enacted a law, tax found to be unconstitutional. Parliament can enact a validating act. Can that be done in the case of a law which violates the basic structure? No. Likewise, therefore, if it violates the basic structure, there's no question of a validation of the law, unless you cure the defect on the basic structure. Right?
That's right.
But therefore, both of these cases, according to you, result in nullity at the point of birth of the...
Birth itself.
Or it's not born at all.
Not
to the
born at all.
Constitution.
It goes to the bill. Please see the.
So what happens if a law violates a fundamental right? Is that law born into the Constitution?
There is a distinction between 13.1 and 13.2. In some cases, and the great jurist, eminent jurist, Mr. CJI, has tried to draw a distinction. He says that both are similar. The judgments are otherwise. He has criticized the judgments. But as the judgments stand, there is a distinction between 13.1 and 2 because 13.1 deals with existing law.
Right.
Yes.
So these laws, pre-constitution laws, they are made before. When made, they were valid. So they can't be knocked down from the inception. They continue by virtue of Article 372, subject to the provisions of Constitution.
Otherwise, the doctrine of eclipse.
Doctrine of eclipse.
Doctrine of eclipse to a
Eclipse.
That's right. And Mr. CJI says not that why should not doctrine of eclipse apply to 13.2 also. But that's a different debate which this court may have to resolve if required. And I don't agree with the esteemed jurist on that point. Hmm. Take two for a second, minute. The procedure is somewhat different from the ordinary lawmaking. Procedure. An amendment of this constitution may be initiated because sub-article 1 says in accordance with the procedure laid down in this article, you have to amend. Then 2 says an amendment of this constitution may be initiated only by the introduction of a bill for the purpose in either a house of the parliament. If I may pause here, no bill violating doctrine of basic structure can be presented at all. And when your lordship declares it violative of basic structure, then the bill itself goes. Where is the question of turning into this act? There is no such thing as act. Procedural, as a matter of practice, it is said Constitutional Amendment Act so and so. It's actually the, and even let me read further. And when the bill is passed in each house by a majority of total membership of that house and by a majority of not less than 2/3 of the members of the house present and voting, it shall be presented to the president, who shall give his assent to the bill. And thereupon the constitution shall stand amended in accordance with the terms of the bill. So the terms of the bill get incorporated. It is the bill which is knocked out by the declaration in para 75.
No, the bill gets transformed into an act after the president signs it.
If your lordship, absolutely right, but if your lordship declares that bill to be violating the doctrine of basic structure, then there was no bill. Which, that's right. So to the extent section 4 is knocked out, that part of the bill goes.
Maybe rise today, there's some.
Yes, sir.
We'll continue tomorrow morning. We'll continue at 10:30 tomorrow morning. About 11:15, if you can wrap up, Mr. Dwivedi,
Yes,
then we can,
11.
the others can continue for another 45 minutes. If Mr. Dwivedi is taking longer, then the others can, in that sense, cut down their arguments, so that between all of you sit down for, we're giving you 1.5 hours and then 1 hour. We take it that Mr. Andarjana, you'll be making the rejoinder now?
Discuss with my
All right.
Okay.